Under the Notice of Proposed Rulemaking, schools are only required to provide written notice of the allegations to the parties after receiving a complaint of sex-based harassment. This notice can also be delayed due to safety concerns following an individualized safety and risk analysis, and those are new elements under the proposed rules. The notice that the schools provide must include a statement that the respondent is presumed not responsible. The respondent may have an advisor of his or her choice throughout the process. The respondent is entitled to access relevant evidence and or the investigative report, and, if applicable, provide an additional notice on the prohibition against false statements. This additional information is not required for sex discrimination matters, which don't even guarantee an advisor of the respondent's choice. Schools are also able to remove a respondent prior to adjudication if they perform an individualized risk assessment that concludes that the respondent poses an immediate threat to the health or safety of another student. The respondent can immediately challenge any adverse decision. And while certain sex-based harassment claims could conceivably rise to the level of requiring immediate removal of the respondent, it's difficult to imagine how a sex discrimination matter would constitute an immediate threat to the health and safety of another student. We're moving on to the investigation process. And on this slide, we can see how changing one word in a regulation can make a huge difference. In a very significant change, the Notice of Proposed Rulemaking allows schools to utilize one person as the investigator and decision maker in Title IX matters. The 2020 regulations explicitly forbid the use of this so-called single investigator model. The single investigator model was regularly utilized by schools prior to the issuance of the 2020 regulations. And while some may argue that the use of this model can be beneficial from a cost and time-saving perspective, federal courts have recognized the inherent danger of such an arrangement. In Doe v. Brandeis, a 2016 case from the District of Massachusetts, the court noted, quote, "The dangers of combining in a single individual the power to investigate, prosecute, and convict with little effective power of review are obvious. No matter how well-intentioned, such a person may have preconceptions and biases, may make mistakes, and may reach premature conclusions," close quote. In our practice, we have come across situations where investigators include irrelevant or prejudicial information in their reports that, if left unchecked, has the potential to sway the outcome of the Title IX matter. While the presumption of innocence remains intact, the Department of Education's decision to allow schools to revert to the single investigator model represents a major step back with regard to due process, both for respondents and complainants. It also jeopardizes the perceived legitimacy of all Title IX proceedings that utilize the single investigator model. Continuing with a little bit more about the investigation, under the 2020 regulations, schools are required to give the parties at least 10 days to review and respond to the evidence prior to the issuance of the investigative report. Schools are also required to provide the parties with at least 10 days to review and respond to the investigative report prior to the hearing. The proposed rules eliminate this clearly defined process and even eliminate the requirement that a live hearing be conducted at all. As currently drafted, the Notice of Proposed Rulemaking only requires schools to provide the parties with a reasonable opportunity to review and respond to evidence prior to a decision being made. If a live hearing is held, the opportunity to review the evidence must occur before the live hearing. Presumably, the opportunity to review the evidence before the hearing must also be reasonable, but the statute as written does not explicitly state that. It's not unusual for there to be hundreds of pages of evidence in the form of text messages, emails, witness statements, and photographs related to a Title IX investigation. In one of our currently pending matters, there is an investigative report that is 20 pages long, which is manageable, but it also includes 320 pages of exhibits. In another matter that we handled, there were close to 700 photographs involved, multiple videos, multiple audio recordings, along with witness statements from almost 10 non-party witnesses and communications that the parties had with each other and with those witnesses. And in these situations, a school's interpretation of what is a, quote, reasonable opportunity to review and respond to the evidence could vary greatly from that of the parties, especially if they are students carrying a full course load. Without a clear time frame, parties and universities are sure to routinely disagree on what is reasonable when it comes to the opportunity to review and respond to evidence. And if the school does decide to offer a live hearing, schools can limit the parties' opportunity to even respond to the evidence, to the actual hearing itself. In other words, the live hearing could be the only chance that the parties have to provide a response to the evidence. This is likely to create an unfair element of surprise for all parties and undermine the ability to effectively prepare for cross-examination, present rebuttal witnesses, and controvert evidence presented by the university or the opposing party.